Chapter 7 is the most common chapter. 3 out of every 4 bankruptcies is the Chapter 7 variety. And that's where someone who doesn't have a lot in terms of assets and a ton of debt, medical bills, personal loans, credit cards.
All unsecured. What if I have
Yeah.
a house or a car? Can I bankrupt them and just keep it free and clear?
No, if you want to keep a house and a car, you have to continue to make those payments.
Okay.
Those are secured items. And by that I mean if you don't make the payment, the lender or the mortgage company can foreclose on the property and recover it. As long as you do not have significant assets, then you could eliminate this miscellaneous unsecured debt. That's the beauty of the Fresh Start. That's why the government put this bankruptcy protection in place. They didn't want you to be stuck with those medical bills and high interest credit cards for the rest of your life. If you're struggling financially, it's affecting your sleep in many cases, your ability to work because creditors can call you at work. You can't pick up your cell phone because you're getting all kinds of collection calls. So there is a drain on you. You start to feel like you're not functioning properly. It could affect your family life with your spouse or with your work or with your church. So it's best to take action and get the relief that you need so that you can be a better spouse, a better worker, feel better about yourself and your situation. Well, the government put in some measures to make sure that people go through some steps before they can file.
So there's some hoops to jump through.
There are some hoops. The first is a credit counseling session, which has to be done before a case is filed.
So what's the purpose of that, and what do they deal with in that?
It's a 1-hour session on a computer or over the phone where a credit counselor is going to interview you, very similar to what you're telling your attorney when you come in for the
So
first
it's a
date.
live person.
It's a live person, or it's done over the internet, and then at the end you connect with a live person to talk about your situation. But here's the deal. Anyone who's doing credit counseling is getting that information from the bankruptcy attorney. So it's just an exercise that they have to go through, pay approximately $15 to a credit counseling company, and obtain a certificate enabling them to file.
Are they going to try to talk me out of filing bankruptcy?
They're not going to talk you out of it. They're going to evaluate your situation. In most cases, they're going to recommend that you're doing the right thing. But they can't really talk you out of it. They don't down-talk bankruptcy. It really is more or less an exercise with very futile results. If the government intended on people to do the counseling and then not file, that's not happening. Well, anytime you file bankruptcy, upon filing, there's going to be the creation of the automatic stay.
What does that do?
This is a big stop sign that tells creditors you cannot call, you cannot collect, you cannot attempt to collect on certain debts while the bankruptcy stay is in place. And that's set up in the system to give you the instant relief in most cases so that creditors stop calling, stop garnishing, stop lawsuits. It just wipes it out, puts a freeze on it while you're going through the process of bankruptcy. And there's the Fair Debt Collection Practices Act, which prohibits certain types of collection activities. Plus, you've got the bankruptcy filing. So now you can go into bankruptcy court and bring a rule to show cause and try and hold that debt collector in violation and maybe get a monetary sanction for their abuse of the bankruptcy code by not adhering to the prohibitions of that automatic stay. Well, Chapter 7's that fresh start. That's where someone doesn't have a lot of property. So we're going to wipe out credit cards, medical bills, personal loans, repossession deficiencies, mortgage deficiencies, utilities, any debt for a type of service. So it's a broad range of debt that can be wiped out under a Chapter 7 fresh start bankruptcy. While student loans at the present time are surviving a bankruptcy. This may change. There is legislation that's kind of going through Congress.
Wait a minute, Dave. I paid my student loans off. I mean, I'm pretty sure that you did yours too. So what would, right now as we sit here and we're talking about this today, what would allow me to discharge my student loans?
Nothing right now, but I'm saying there may be legislation pending. Student loans are here, non-dischargeable for the moment.
What if I got a loan from a bank that wasn't necessarily designated student loans and that's what I used to pay?
Anything for an educational purpose is non-dischargeable with the exception, and I've never seen this happen, where you can convince the court that to keep the student loan on you would be an extreme and undue hardship. And in my experience, you have to be basically unable to work or function, and at that point, the student loan wouldn't be collecting on you anyway. So it really is a misnomer, in my opinion.
What's the type of legislation that's pending to lighten that up?
Well, the student loan debt, in terms of dollars, is out of control. So there's grumblings in the court and from people to try and come up with a way to help people who have student loan debt. There was a time, Jesse, where if a student loan was more than 7 years in repayment status, it was eliminated.
And that was in a bankruptcy?
That was in a Chapter 7 bankruptcy, but the law changed. I think it was in 1998, I believe. And since then, student loans of all different types and for educational purposes are non-dischargeable. So if you take out that student loan, plan on paying it. You are going to appear in front of a Chapter 7 trustee. Your attorney will be there with you, the trustee will be there, and any creditors have an opportunity to appear. It's really known as a meeting of creditors, which is mandated by the Bankruptcy Code, and the trustee just wants to interview you, ask you a series of yes/no questions.
Based upon your petition, right, to make sure that you've answered those questions and they're true and correct and accurate and you haven't left anything out. You didn't forget about that paid vacation property that you have in Maui.
Right. The trustee is doing an investigation on a very minor level based on the documents you filed to make sure that you qualify and that you don't have any significant assets that can be taken and administered to pay your creditors.
So why would a creditor waste his or her time?
Well, most creditors will not appear. It's referred to as a meeting of creditors in the Bankruptcy Code, but typically creditors are going to let the trustee do his or her job to see if there's any assets to be administered. Where you may find a creditor appear at a meeting is if the creditor feels that there may be an asset or there might be some type of fraud. It could be a very large purchase too close to filing. It could be a cash advance too close to filing. It could be a transfer of an asset where the creditor knew you had a car because you put it on your loan, and then all of a sudden on your schedules, that 2016 Cadillac that you said was paid in full doesn't exist, and you didn't disclose it as a transfer. So there are things where people get into trouble with non-disclosure, and creditors can bring that to the trustee's attention. Chapter 7 bankruptcy is a very generous statute. It allows you to eliminate debt and yet keep a certain amount of property. Now that's mandated by the Illinois statute, which allows you to keep up to $15,000 worth of equity in real estate, $2,400 of equity in a vehicle, all of your retirement as long as it's ERISA qualified.
So if I have $500,000 in ERISA qualified retirement, I get to keep all of that?
Yes, you also keep $4,000 worth of miscellaneous property known as the wild card exemption, which you can sprinkle over any type of personal property other than real estate. So you can file bankruptcy and keep a fair amount of property here in the state of Illinois. It's a very generous statute.
And in fact, in addition to the $15,000, that's per person. So if it's just me filing and not my spouse, obviously she has an interest. If it's in joint tenancy by the entirety or joint tenancy, she owns half of the undivided whole, and so half of that belongs to her, right? So that would be like $30,000. So 15 and 15, would that be correct?
That's correct. Each spouse is entitled to an exemption if they're filing together. In the situation that you gave, the non-filing spouse still is entitled to their 50% share. So the trustee has to figure how much equity is available after I give the non-filing spouse their share.
Their share. So, and she's entitled to all that. So, well, let's say a situation where my in-laws are on the house too, because they contributed and bought my wife and I a house. Okay, so now we've got like 3 or 4 people on the property. Same thing applies. You just cut down the amount of ownership in that.
Right. The trustee needs to give all the owners their specific share, and then the trustee has to look into the cost of the sale. There's realtor fees, legal fees, insurance fees. What is a trustee actually going to net?
Title fees, right.
Title fees.
So so it's really, even though it's $15,000 per person, you got a little bit more based upon all those other things, because it's not going to be worth it to sell it to realize $500 essentially.
That's right. It's going to be a little bit more because there's a cost of sale involved
right
in these properties. You are definitely going to get credit again after a bankruptcy if you want credit. It typically takes about 6 months to a year to establish some forms of credit. You can purchase a vehicle financed immediately after filing, and you can get other types of credit after about 6 months to a year.
Wow, 6 months to a year. All right. So as time goes on, as long as I continue to pay, though, right?
Right.
That's what's going to happen.
You have to maintain good credit and not fall behind on other outstanding obligations.
How often can I file a Chapter 7?
You can file a Chapter 7, believe it or not, every 8 years.
Every 8 years?
Every 8 years. Now, hopefully when you file your first and only
Right.
bankruptcy, you don't need to file again. But if you do, if things happen in life, maybe you lost your job, divorce, medical situation, you do have the ability every 8 years to file a fresh start Chapter 7.
Okay.
And if you're within the 8 years, there's a Chapter 13 option for you. One of the requirements before a case is officially over is a 2-hour personal financial management instruction course. And it's basically a 2-hour session that talks about everything from insurance, finance, purchases, identity theft, protecting your credit, all kinds of different things, just to give you a general kickoff to your new fresh start with a little bit of knowledge.
Okay.
Most people have said that the class is helpful as opposed to the credit counseling at the beginning, which they find was wasteful. The 2-hour financial management class, people do get something out of that typically. Well, it's going to depend. There's attorney's fees that range depending on the type of attorney, the experience level, and the service level. And of course, there's a court filing fee, which will vary. It continually goes up, but right now it is set at $335.
And that just is the filing fee.
That's just the filing fee that goes to the clerk of the United States Bankruptcy Court for the privilege of filing of a petition and getting out of debt.
Well, I mean, doesn't it seem, kind of wonderful to be able to spend $300 or whatever the attorney's fees are and to discharge $150,000 in unsecured debt?
Well, if you are someone who is in a position where you don't have the ability to repay and you don't have significant assets, then you can afford yourself for the relief. But people do not set out to file Chapter 7 bankruptcy. They don't say, boy, I'm going to run up some debt and then run into a bankruptcy attorney and pay a filing fee and an attorney fee and get out of debt. That's just not how it works. Your job does not need to find out. They do not need to know. With the exception, if you're currently being garnished, then the bankruptcy attorney is going to send something to your employer notifying them to stop the garnishment. But your employer does not need to know about your bankruptcy case.
With that exception, obviously they know by implication, obviously, if they've received something like that.
Certainly the payroll department, the
Right.
human resources.
But not everybody. I'm not going to, bump into Fred and, hey, I heard you filed bankruptcy there, Unless Fred is, of course, in the human resource department, right?
Right.
Okay.
Right.